San Antonio police make an arrest in a capital murder case. Curtis Ray Wilson was arrested yesterday, charged in the shooting death of two teens. It happened on September 18th on the 200 block of Noblewood Drive. Two other suspects are also wanted in connection to the shooting.
This is one of the most intense courtroom face-offs you'll see this year. Curtis Ray Wilson, charged in a brutal double-teen homicide, stands before Judge Boyd, and things escalate fast. From multiple felony charges, conflicting pleas, emotional family support, to Judge Boyd's relentless questioning, this isn't your average courtroom scene. But here's where it gets wild. Wilson claims ignorance, says he just went along for the ride. But Judge Boyd, she's not buying it, and her reaction is everything. Keep an eye on the timelines. We're going from formal charges to a near explosion of emotion in minutes. You'll witness shocking inconsistencies, failed courtroom strategy, and a judge determined to get to the truth. And just when you think it's over, a jaw-dropping twist leads to a remand without bond. Let's break this down.
Wilson, can I have parties announced for the record? State.
Antonio Arriola.
Defense.
Written error for Mr. Wilson.
And are you Mr. Wilson?
Yes, ma'am.
And cause number ending in 27B, you're charged with deadly conduct, discharging a firearm in count 1 and count 2. Is that correct, state and defense?
That's correct, Judge. Yes, Judge.
All right.
This moment marks the calm before the legal storm. Both parties affirm the charges: deadly conduct and aggravated assault with a deadly weapon. But it's the phrasing that matters. Discharging a firearm paired with deadly weapon means this isn't just reckless, it's potentially fatal intent. Judge Boyd immediately frames the severity by laying out the range of punishment, up to 20 years and hefty fines. And yet, Wilson stays quiet, almost too quiet. No reaction, no objection, no visible concern. It's as if he hasn't fully grasped the gravity. This silence, it's going to come back later, because when the judge probes for accountability, the courtroom dynamics completely flip. But for now, pay close attention to how Wilson's team plays it cool. It's either confidence or pure miscalculation.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 28B, you're charged with the offense of aggravated assault with a deadly weapon. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to your plea bargain agreement, the cases are to run concurrently. The state is taking in consideration 2024 CR 3009, County Court cause number 732604.
Let's break this down mid-dialogue because this part is crucial. Judge Boyd outlines the plea bargain, and it's not light. 2 cases, 2 separate cause numbers, both with affirmative findings of deadly weapon. This means he's not being charged as an accessory or by mistake. The court is saying he had direct knowledge or involvement with a weapon. Now, here's the twist. The state opposes deferred adjudication. That's legal code for we don't trust this guy not to reoffend. And it sends a signal to the judge. Wilson is not a candidate for leniency. The judge also makes it very clear, even if deferred adjudication is granted now, any misstep later allows the court to revoke it and slam him with the full 20-year sentence. This is the kind of legal noose that tightens fast. And Wilson's team, they nod along.
And in the plea bargain agreement ending in 27B, state is proceeding on counts 1 and 2. Punishments be assessed at a cap of 10 years in the prison. There's a $2,000 fine. There is affirmative finding of deadly weapon, and the state is opposed to your application for deferred adjudication. There's to be restitution, if any, to the complainants. And then in the cause number ending in 28B, there's a cap of 12 in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application. There's to be restitution, if any, to the complainant. Did you understand that to be the plea bargain agreement in each cause number?
Let's pause here, because what just happened was huge. Judge Boyd asked the most basic yet powerful question, "Did you understand the plea bargain?" And Wilson says, "Yes." That response might seem standard, but it seals the deal. It confirms he was informed, aware, and in agreement with all the terms laid out, including the deadly weapon findings and opposition to leniency. This means any argument down the road about not knowing or not understanding, it's already dead in the water. The judge is building her legal foundation carefully, and Wilson is stepping right into place. Every yes ma'am in this moment is a lock on the door behind him.
Yes, ma'am.
Then, and cause number ending in 27B, how do you plead to count one? Guilty, not guilty, or no contest?
Okay, no contest,
Count two, how do you plea?
no contest,
And in the cause number ending in 28B, how do you plea?
no contest.
State any evidence.
For each case, the state offers State's Exhibit 1 with attachments.
We've reviewed them and have no objection.
In each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. We're going to come back on December 19th. I'm going to ask for a PSI TAP evaluation. On the 19th, I'll review whatever evidence is presented to me and make a decision on your application.
This is the pivot point where everything could change, but probably won't. Judge Boyd agrees to review the PSI evaluation and defer the decision on adjudication, but listen carefully, she doesn't commit to anything. This is courtroom diplomacy, giving the defense time to gather more favorable information, possibly letters of support or psychological evaluations, but the undertone, it's skeptical. She knows the state isn't playing around, and the facts already presented don't exactly scream first-time mistake. If you've been watching courtrooms long enough, you'll recognize this strategy. Delay the slam while hoping the judge reconsiders. But Judge Boyd, she's already keeping score.
All right, is there anything else from either side?
No, Your Honor.
Nothing from the defense.
All right, thank you. R2928B, State versus Curtis Ray Wilson. Can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Bud Rittenhour for the defense.
And are you Curtis Wilson?
Yes, ma'am.
All right, you entered a plea on November 7th to aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application for deferred adjudication. This will run concurrent with 2024 CR 2927B. And the state is taking into consideration some cases. All right, and also 2024 CR 2927B. And that cause number, you enter pleas to count one and count two. The state waived count three, and that's a deadly conduct discharge of firearm. And according to that plea bargain agreement, punishment is to be assessed at a cap of 10 years, and it's to run concurrent with 2024 CR 2928B.
This is a major reset. We're now in a new hearing date, and it's clear Wilson's team is scrambling to control the damage. Judge Boyd recites the plea deal again, with the same harsh terms: deadly conduct, discharging a firearm, 10, 12 years in prison, $2,000 fines, and no leniency. But here's the problem. The court isn't just repeating itself, it's stacking weight. Each clause confirms the same story from a different angle. That's how the judge builds pressure. And Curtis, still minimal reaction, still not fully acknowledging the situation, and it shows in the courtroom tension. But the most telling moment, when the judge says state opposes your application, that's the state officially throwing down the gauntlet. This case is now officially past the mercy zone.
And there are two other cases that are being taken in consideration. Any witnesses, state? Defense, any witnesses?
Judge, we have none to testify. I provided the court a motion I filed this morning with statements from members of the family. We do have three members of the mother, father, and stepfather are present in court in support. They're not asking to testify.
All right, any objection to the court reviewing the letters of support?
No, Your Honor.
All right, just give me a moment. Let me review that. And the letters of support are from the defendant's father, former teacher, cousin, stepfather, and mother.
That's correct.
All right, the court has reviewed the letters.
This is where things take an emotional turn. The defense presents letters of support from Wilson's mother, father, stepfather, cousin, and even a former teacher. On the surface, it paints a picture of a young man who has community backing and potential. But Judge Boyd? She doesn't immediately respond with sympathy. She simply says, "The court has reviewed the letters." Translation? "I've seen them, but I'm not moved yet." This courtroom has likely seen hundreds of these letters, and unless there's substance, they're often seen as routine defense strategy. Still, this was Wilson's shot to humanize himself, to show more than just a rap sheet. It's a calculated risk, one that might have meant something if what came after hadn't derailed it completely. This is where the real unraveling begins.
All right, defense.
Obviously, we're asking for the deferred adjudication, Judge. We'll get here in both cases by law of parties and not by direct action by him. Mr. Wilson was 19 years old. In fact, he turned 22 months ago. At the time of this offense, he has graduated from high school, actually withdrew from Sam Houston, finished it online, home tutored by his mother. He had just gotten with the wrong people, going places, not questioning where he was going. He and I have talked a great deal since he's been incarcerated. He understands that you can't just pick up with people and go, not ask what's going on. He has some positive plans, as indicated by the letters, for his future. The young man has a good head on his shoulders and a good positive attitude and definite plans for the future.
Here, the defense is in full mitigation mode, painting Wilson as a misguided teen who simply fell in with the wrong crowd. He was home tutored, motivated, ashamed, and wants to be a truck driver. All noble aspirations, but Judge Boyd isn't interested in vague future plans. She's listening for one thing: accountability. The defense carefully avoids saying the word guilty. Instead, they frame Wilson's presence at the scene as passive, a mere passenger in the vehicle. But in criminal court, intent and association matter just as much as direct action. It's a compelling speech, full of hope and narrative, but it's missing one crucial piece: remorse, backed by ownership. And if you know Judge Boyd, that's a deal breaker.
Sending him to prison at this point in his life is certainly not going to do anything for him or society. Giving him a chance on deferred, understanding the full weight of the punishment is pending over his head, should he not make it. He's motivated to finish that, get out there, get training, and just become a productive member of society. He intends eventually to own his own business, looking at truck driving and some other things. So he's looking at the future. He's had a lot of contemplation since he's been in custody. He certainly does not apologize, is not the right word. He's almost ashamed that he was involved in this thing. At the scene, he was a passenger in a vehicle. He knows he shouldn't have been there. We're asking for the court to give him a chance.
Okay, the defense is saying that he did not know what was going on or what was going to happen. Do you have any response for that?
This. Everybody makes mistakes. You make a mistake, don't do it again. I got caught up with something because I was with other people. Well, Mr. Wilson doesn't actually acknowledge what mistake it is that he has made. And as far as I can tell, abdicates responsibility for the choices that he made. He got caught up with something because he was with other people. Not, he chose to be with those people. He chose to do what they did. He got caught up. As far as I can tell, Mr. Wilson still refuses to take responsibility for his choices. And as long as he's going to refuse to take responsibility, he belongs in prison.
This is the turning point. Judge Boyd drops the hammer. and doesn't hold back. In just a few sentences, she dismantles the entire defense narrative. Her words cut deep. He doesn't acknowledge what mistake he's made. He abdicates responsibility. He still refuses to take responsibility for his choices. And then the line that echoes through the courtroom. He belongs in prison. This is no longer a debate, it's a declaration. Up until this point, the defense has been pushing for deferred adjudication. Now, that door is slamming shut. What makes this moment so intense isn't just the judge's words, it's the tone. She's not angry, she's resolute. This is someone who has weighed the facts and made a firm judgment. And from here, there's no walking it back.
All right, so I'm reviewing the facts of the case, and in the facts of the case, it says that they were, the person identified him because they knew him from school. He identified which position he was in, and that a person went in with a mask on. So at what point are you not aware of what people are doing? That's what I'm trying to figure out.
The question was about what was going to happen, what was happening at the time when everything is happening. Well, he was with the people, they were going to do something. He went along with it. His mistake was not understanding what was going on, not asking questions about what's going to happen.
So he's saying that,
When people, actually, there were multiple cars involved in this case. The one that he was in didn't have anybody in a mask. That came out of a different car. He never left the vehicle he was in. He didn't have the firearm.
all right, if he's saying he didn't know,
Arguing about whether or not the other people had firearms or not in that vehicle.
all right, if he's saying he didn't know about this plan and he wants a jury trial, I'll give him a jury trial. But based upon what I'm reading in the reports, I don't think he's a good candidate for probation.
Let's zoom in here. Judge Boyd just gave Wilson an out. She basically said, if he wants a jury trial, I'll give him one. But what follows is more telling. I don't think he's a good candidate for probation. That's a quiet but brutal rejection. Wilson's defense team knows the odds just tanked. They were hoping for leniency. Instead, they got a subtle warning that Judge Boyd is ready to lock in sentencing. Here's the strategic nuance. Asking for a jury trial at this point isn't about proving innocence. It's about damage control. The judge is done negotiating. She's throwing the gauntlet down. If you want to roll the dice, go ahead. But don't expect mercy later. The tension in that courtroom, off the charts.
Let me talk to my client.
Sure. All right. So what is it? Just a second. We're back on the record in 2024 CR 2927B and 2024 CR 2928B. Defense, did you have a chance to confer with your client?
I have, Your Honor, and given the choices we have, we'd ask that we'd like to withdraw the plea and get trial setting.
All right, Ms. Ferguson, can I have a jury trial setting on Wilson? State, how long do you expect this trial to last?
4 days.
All right.
You can do March 4th.
All right, your jury trial date will be March 4th.
Understand?
Thank you. So I'm gonna call the docket. When I call the docket, I need to hear on Curtis Wilson. All right, where's Mr. Wilson?
Your Honor, state tells me he has left the building.
All right, so I'm gonna issue a warrant for his arrest.
Judge, I'm asking that he be remanded without bond.
I'm gonna issue a judge's warrant and remand him without bond. And we're gonna go on the record. Court is calling 2024 CR 2927B, 2024 CR 2928B, 2024 CR 3099, State versus Curtis Wilson. Can I have parties announced?
Megan Galloway for the state.
Blood written hour for Mr. Wilson.
All right, this hearing is scheduled at 9 a.m. I did notate that I saw Mr. Wilson in the courtroom. Did he show up for court today, counsel?
He did, Judge.
All right. And Deputy, could you make an announcement for Curtis Wilson in the hallway, please? All right, thank you. All right, defense, do you know where your client is?
Do not, Your Honor.
All right, state.
Your Honor, I'm asking that the court issue a judge's warrant and remand the defendant without bond.
All right, the court will issue a judge's warrant in each cause number and remand your client without bond. And the court did today receive a violation report. Counsel, have you had a chance to review that?
Given to us about an hour ago, Judge.
All right.
This is the moment everything collapses. Wilson doesn't show up. The state says he left the building. What does Judge Boyd do? Issues a judge's warrant and remands him without bond. Let's be clear, in legal terms this is DEFCON 1. Leaving court after being warned. That's a violation of judicial trust. And in serious cases like this, it's often interpreted as flight risk or contempt. This wasn't just poor judgment. It may have tanked any remaining hope for reduced sentencing, no matter how compelling your letters of support are. Once you walk out mid-proceedings, the court shifts from patience to punishment. Now with the judge reviewing violations on record and bond revoked, Wilson is done negotiating.
All right, thank you.
Thank you, Judge.
Sure. Court is calling 2024 CR 2930 and 2024 CR 2928A. Could I have parties announced for the record for the state,
Jason Garrett.
defense?
Melissa Christian.
And are you Mr. Yanes?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client? And the cause number ending in 2928, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 2930, you're charged with aggravated robbery. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each case, punishment is to be assessed at 16 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The causes will run concurrently with each other and also concurrently with 723230. The state will take in consideration 2024 CR 2930. And in the cause number ending in 2928A, you agree and confess, judicially confess that you committed these acts with Curtis Wilson. Did you understand that to be your plea?
Yes,
And
ma'am.
in the cause number ending in 2930, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ending in 2928A, how do you plead? Guilty, not guilty, or no contest?
No
Are you
contest.
proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Judge, we've thoroughly gone over the paperwork and Mr. Yanes clearly understands his position in all of these cases, and we would just ask that the court follow the plea bargain.
All right. Then in the cause number ending in 2928A, the court will find you guilty, sentence you to 16 years in the prison. This is run concurrent with 2024 CR 2930, County Court cause number 723230. Taking in consideration 2024 CR 2927A. And in that cause number, the court is finding, based upon your plea bargain agreement, that you acted in concert with Curtis Wilson. And there's an affirmative finding of deadly weapon. The court will give you credit for any time served. Anything else with regards to sentencing under that cause number?
No, ma'am.
And cause number ending in 2930, the court will find you guilty, sentence you to 16 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2024 CR 2928. 723230, taking in consideration 2024 CR 2927A and give you credit for any time served. Is there anything else with regards to sentencing in that cause number?
No, ma'am.
We can go off the record. How old are you?
20.
All right, you're 20. I know that's a lot of time. Any time that people do in custody, even if it's a day, it's a lot of time. But you still have a chance to improve your life. When you go to the prison, I understand that sometimes people will join organizations for their safety, but do not go to prison and become institutionalized. You have a chance, if you don't have your high school diploma, you have a chance to get your GED. You have a chance to get a college degree. You have a chance to get a trade, so when you come back out, you can change your life. You understand? And when you're released, if being in San Antonio is not helpful for you because of the people you surround yourself with, then leave.
So here's where everything lands. Curtis Ray Wilson, once just another name on a docket, is now locked into multiple felonies, with affirmative findings of deadly weapon, multiple failed hearings, and a judge who publicly rejected his defense strategy. His co-defendant got 16 years. Wilson, he's walking toward a jury trial that may hand down even harsher consequences. And let's not forget 2 teens are dead. A gas station shootout, a chase, a standoff. Letters of support weren't enough. Neither were the courtroom speeches. What sealed his fate was his refusal to take responsibility. Judge Boyd didn't just rule. She laid down a statement: if you stand before this court, own your choices. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.